Good morning. It is wonderful to be back with everybody for another EO Exchange event. And what a privilege it is to introduce our 16th installment of these. This morning, I have the pleasure of introducing our strategic alliance partners, Baker Donelson and Alliance Bernstein, as they share how to get your financial house in order. A discussion on the need for wills, trusts, estate planning, diversifying your portfolio, and what to do if all your assets are in the business. In our last 15 minutes of the morning, we want everyone to make connections, just as we do before and after our live events. So we will place you in a small group exchange with some thoughtful prompts to get the conversation going. You'll want to stick around, so be sure to hang out all the way until the end. We will also have some time for Q&A. So as our panelists are speaking and you have questions, just feel free to drop them in the chat, and then we can come back and visit those about halfway through. So as some quick introductions for our all-stars today, Steve Wood with Baker Donelson focuses his practice in the areas of federal and state income taxation, estate planning and administration, business law, including corporations, partnerships, and LLCs, and tax-exempt organizations. Steve is also a CPA. He has represented professional athletes in devising their estate plans in the US and abroad. He has served on several boards and been named 2015 Nashville Trust and Estates Lawyer of the Year and 2018 and 2013 Nashville Nonprofit Charities Lawyer of the Year. Tom Pulaski is National Managing Director of Wealth Strategies with Alliance Bernstein, working with private clients and their advisors on wealth transfer strategies, focusing on tax-efficient wealth management and asset allocation decisions. He has been an adjunct professor at Loyola University Chicago School of Law and has taught estate planning classes at Northwestern University Law School. He retired as a commander from the U.S. Naval Reserve in 2003 with 21 years of combined active duty and reserve service. Amazing. Thank you for your service, Tom. And as a fun fact, Tom also went to high school with Drew Carey, the current host of The Price is Right. And just to piggyback off of that fun fact, I was once a contestant on The Price is Right, but it was pre-Drew. So, you know, that's awesome. Adam Sanseveri is the managing director and head of the Nashville Private Client Group for Alliance Bernstein, and he will open us up this morning. Adam serves on 5 nonprofit boards in Nashville. And as a fun fact for Adam, well, we have 2 fun facts for him. One, he has likely the most pro and badass Zoom situation I've seen yet. That's one. And second, Adam was an Ivy League champion in the pole vault and is a classically trained musician that has performed at the Met Opera and Carnegie Hall in New York City. So with that, Adam, take it away.
Thanks, Brandon. Appreciate it. And hi, everyone. Thanks for letting us be with you today. In the few weeks that AB has been a strategic partner for EO, we have had a blast presenting at a few forums and events, and hopefully today will be equally as fun and helpful. For those of you that we've not met, just really quickly, AB is the largest independent investment research firm in the world and one of the top asset managers with over $700 billion under management. A primary focus of the private client group is working with business owners. So the combination of these 2 things, I hope, means a lot of knowledge that we can share with all of you, a lot of experience on a wider range of topics that will be helpful. So please reach out to us. Let us know how we can be helpful. We're very excited to be a partner with all of you and happy to be here today. So with that, I will turn it over to Steve to kick us off.
All right, thank you, Adam, and thank you, Brandon. Appreciate the introduction. I have provided an outline. It's our presentation and our talk is going to roughly follow it, but we will probably stray, and we're going to have to cover a lot of topics in a short amount of time. So wish we had longer time to discuss, but everybody has their work to get on with. So if you'll turn to the first page in the outline, Marla, in being a business owner, and to the next page.
Sure.
In being a business owner, and really thinking about what you need to have in place, how to keep your house in order. Everyone, I would say everyone needs, who is an adult, needs a will and or a revocable trust, basically to decide, okay, I have all these important assets, what happens to them and who's going to control that. Absent a will, you're basically, you're leaving it to Tennessee law to determine who's in control of these assets. You may have special issues that require, more careful planning. Of course, taxes are always important, and we may mention that briefly today, but you also have other issues, second marriages, significant others, planning for those, special assets, your business, and how that's going to be dealt with as part of your estate. Children, who will be the guardian for your children? So for all those reasons, I think in order to have your house in order, I think everyone should consider that. So if you'll advance to the next page, Marla. In Tennessee, anyone who is 18 and over may make a will. Tennessee, we have basically three types of wills. One is the typewritten will that you are familiar with. It requires two witnesses. They all must be in the same room. Even though we tell people they have to be disinterested, that's not technically the case. They just can't inherit more under a will that they witness than they would under the statute. However, it's good practice to have disinterested people witnessing a will. And then we use a self-proving affidavit so that you don't have to bring witnesses to court. The other type, I won't even address the third one listed, is a handwritten will. Gosh, for those who don't have will and you're going on a trip and you can't get someone to prepare a will for you in time, a handwritten will is probably better than anything. And all the material terms have to be in your own handwriting, and it has to be signed and dated by you. It can't be typed. However, they're more difficult to prove. So once you get back from that trip, my recommendation would be, if you didn't have a will before, to get a will drafted. So Marla, if you will advance to the next page, please. Also wanted to mention revocable trust, or what some people refer to as living trust. People also will sometimes refer to these as will substitutes. From a practical matter, typically when they're used, you do not avoid probate. However, if all of your assets, let's say you own a business interest, you own investments, marketable securities, you own a home, you have insurance. If all of those assets are either payable to the trust or are owned by the trust, technically you can avoid probate. One of the major benefits of a revocable trust is the privacy aspect. In the event of your passing, with a will, if you have assets that are subject to probate, the will has to be filed with the probate court. With a revocable trust, that trust is not a part of the probate record. So the dispositions under that trust, the restrictions under that trust are not part of the record. Also with a revocable trust and a will, you're going to name, again, those people who are responsible for the administration of those assets. It might be that you want to divide those duties. You might have a special trustee to deal with your business asset and another trustee to deal with everything else. As mentioned there is some paperwork on the front end if you want to use a revocable trust, although there typically is paperwork on the front end when you just have a will that deals with the disposition of your assets. So that's not a major hurdle to overcome. Marla, if you advance to the next slide, please. And I've mentioned some of these: wills versus revocable trust. Wills are going to generally be recorded. You will file at the courthouse, and everything that is part of that will be public record, and third parties can come view it. Revocable trusts, they are not part of the public record unless you have Glenn Campbell's situation and you have litigation. Then it may become part of the probate public record unless it's sealed. Wills must be probated if there are assets in the probate estate. There are certain exceptions to that, however. If you have what's called a small estate in Tennessee, which is less than $50,000, you can actually go down to the probate court, the clerk and master's office, and get the assets transferred with something called a small estate affidavit. Wills versus revocable trust in states such as California, New York, and other states that have, I would say, detailed probate processes, fees based on the size of the probate estate. There's special consideration in those states. Also in community property states, which Tennessee is not one. Elderly parents. If you have elderly parents who have significant assets, revocable trusts are very handy in dealing with those situations, especially if they want one or more of the children to serve as trustees. It provides a means for managing those assets as your parents age, which all of us do. So if you would advance to the next slide, Marla. So what happens without a will? Very short, that's called intestacy in Tennessee. In Tennessee, if you were married, everything passes to the spouse if there are no children. If you have one child, everything passes equally to that child and the spouse. Now, this does not apply to the extent you own jointly titled property, or you have insurance policies that are payable to a spouse or a child in that situation. But everything that's part of the probate estate is split equally. If you have more than one child in Tennessee, 1/3 goes to the spouse and 2/3 gets distributed among the remaining children. And the last point is, and I've mentioned this before, is that a court-appointed administrator ends up administering the estate. Now, that might, in the order of preference, that would be a spouse and a child, but it still might not be the person you would have chosen to do that. So, Marla, if you'd please advance to the next. All right, powers of attorney. Wanted to touch on those briefly. Powers of attorney basically are appointing an agent to make decisions for you in the event that you're unable to do that. Power of attorney, in order to survive your incapacity, must be what's called durable, which requires specific language in the document. As far as your business interests, if you ever became incapacitated and didn't have one of these in effect and didn't have some type of contractual provision, you may have to go through a conservatorship. So this is one of the means of addressing those type issues without the need of appointing a conservator. You may also want something called a limited power of attorney, where you name one person to deal with all of your assets and a second person to deal with your business interests. And that can be done. Marla, if you would turn to the next slide, please. Oh, this is what you don't want to happen. So if you don't have a power of attorney, as mentioned in Davidson County, and you have assets to deal with and you become incapacitated, you would end up being in Judge Kennedy's court, and someone would be appointing a conservator for you. And the conservator can basically take control of whatever aspects the court approves, which can be your health care, can be your financial matters, and take away that particular incapacitated individual's rights with respect to those decisions. Again, this might not, the person who petitions the court in his name might not be the person that you want. So if you would advance the slide, please, Marla. All right, so who needs a power of attorney? I think everyone does that's an adult. As we go through this, if something happens, I'm incapacitated, I'm certainly going to want, in my situation, to name my spouse. So each of you may have someone that you would want to name. And those of you who are business owners, you're going to want someone to deal with that, and it might not be your spouse in that situation. That's what you would do with the power of attorney. All right, please advance, Marla. Another thing that a closely held business owner should consider, especially if you have partners, shareholder agreements and operating agreements. Operating agreements typically are used with limited liability companies. If it's a partnership, you'll have a partnership agreement. If you own an interest in a corporation, it'd be a shareholders agreement. Well, some of the events that are addressed in these documents would be, what happens to my interest in the event I suffer a long-term incapacity? What do my remaining partners do? Do they have the right to purchase me? If so, at what price? And if so, have we provided a mechanism for purchasing that interest? They may address other things also. I just want to leave the LLC, or I just want to leave the corporation. What are my rights, and what can my remaining partners do, and what would be the terms of the exit if I left? Marla, if you would advance on to the next slide.
And hey, Steve, I think it's my job as moderator to keep us on time. So just wanted to check in, and so just wrap up when you can, if you can. Thanks.
Yeah. And I think I would just wrap it up with this slide. So I mentioned tax early on, and that's one of the big drivers in some of the estate planning documents that you might execute in the future or already have in place. And I can tell you, when I started my practice, the estate tax exemption was $600,000. The gift tax exemption was $600,000. The generation skipping tax exemption was $1 million. You can see what they are now down the bottom line. And we have a lot of discussion right now about what's going to happen to those. If nothing happens, they go back to the prior line level in 2026. However, just stay tuned. I think there are going to be some changes before then. And with that, I'll turn it back to you, Adam.
Thanks, Steve. That's a great slide too, especially as folks think about the valuation of their businesses. Tom, throw it over to you.
All right, thanks, Adam, and thanks, Steve. That was a great overview, sort of the basic estate planning kit for a business owner of a will, revocable trust, power of attorney for property and healthcare, and then certainly buy-sell agreement, shareholder agreement to cover the business issues that would be attendant. in the event of a disability or death. Super good stuff. And that last slide you showed on the history of the estate and gift tax, and particularly the amount that may be excluded from those taxes, is pretty enlightening, because right now in Washington, there's a lot of talk about changing again what those rules would be. And the threats are pretty significant. We don't know exactly what Congress is going to be able to do. The Democrats have the slimmest of possible margins in the Senate, and not much better in the House of Representatives. So what they'll actually be able to do is undefined at this point. But what they've talked about doing is pretty significant. Basically torpedoing most of the estate planning strategies that Steve and other estate planning attorneys use to help business owners move assets down a generation or two to avoid estate taxes. Potential reduction in the exclusion amount that Steve showed on that last slide, and the possibility that upon death, any appreciated assets that someone owns would be subject to a capital gain tax at that time. Now, there's plenty of talk among the moderates in Congress about changing that to say, well, certain business owners would be excluded from that. Family farms would be excluded from that rule. But these are all things that are very serious, but we don't know how many of them are going to come true. And we also don't know when those actions might become effective. Congress can, if they choose to, pass retroactive tax laws. And that's particularly important to the business owner, because one of the proposals made by the Biden administration, and this has some support among the Democrats, especially the progressive Democrats in Congress, is that the capital gain tax rate would be doubled, essentially, for anyone who has adjusted gross income of more than $1 million. Restated, anybody who sells their business this year might pay twice the capital gain tax that they thought they were going to have to pay. And such a provision could be made retroactive. The Biden administration has proposed that provision be passed and that it be made retroactive to April 28th, which is the date that he addressed the joint session of Congress. So if you're in the process of thinking about selling your business, one of the key questions should be, what is my tax rate going to be? And the answer to that question is, I don't know, because Congress may already have changed the tax rate and not had the courtesy to tell us about it, because they can pass retroactive legislation. So how should you look at this? You're a business owner. What should be your take? Start at the beginning. There are 3 phases that you need to think about. How to do estate planning while you own the business, which Steve covered very thoroughly. How to do estate planning if you're in the process of selling your business, and how to do estate planning after you've sold your business. And for that matter, financial planning as well. While you own your business, you have to think about a future that you're not a part of. What will happen to my family? What will happen to my business if I'm not there? And if your family is dependent upon the salary that you receive and is not going to be able to take distributions from the business, you have to consider how you're going to fund lifestyle for your survivors. And most people will use life insurance, especially as a young entrepreneur. You can get life insurance, especially term life insurance, at a very small price. And Steve would advocate, as I did when I was a practicing lawyer, setting that up so that the trust is, so that the life insurance is not something that you own personally, but is held in a trust that would be for the benefit of your surviving spouse, if any, children, grandchildren, and anyone else that you designate to benefit from that policy. You're gone, your earning power is gone, and perhaps your ability to take distributions from the business or your family to take those distributions may be impaired, but you will have protected them through this. So if any of you have a situation where you're thinking, I don't really like life insurance, I view it as a necessity, but not something that I prefer to have, and you want to have an analysis done for you that would help you understand how much insurance you would need, I'd be happy to facilitate that along with Adam. AllianceBernstein does that for clients and non-clients alike. We do not sell insurance. We have no skin in the game. We're not going to make any profit out of any recommendation that we would make. All we want to do is help you understand how you might make financial ends meet. And if insurance is a gap filler that you need, that would be something you should think about. If you're thinking about selling your business, especially this year, multiples being what they are. I was in a meeting a week and a half ago, and somebody is considering an offer for 16 times EBITDA for their business. I said, what are you considering? Just take the money. I don't care what your tax rate is. You're never going to see that again. But the multiples that we're hearing in some meetings are just crazy. but you do have to think, how much are you going to get after taxes? And are you going to have a continuing interest in the business going forward? One of the great things about estate planning is if you happen to have a private equity group that would come in and monetize a portion of your business, but require you to stay on and retain some equity stake in the business, that rolled over equity interest is a great opportunity to do some estate planning now, especially in this environment when the exclusions for gift and estate tax purposes are so very high, as Steve just showed us on that last slide. The opportunity to take some of that rolled equity, or if you just have perhaps a transaction in the future, or you just want to pass your business down portion of the equity interest to other generations, the ability to transfer that in the current environment is very, very profound. And again, Steve would, I'm sure, love to have that conversation with you. Adam and I would love to have that conversation with you. We don't compete with Baker Donaldson. We work synergistically with them. We're a financial firm. They're a law firm. You need help from both in order to make these kinds of decisions. And we'd be delighted to help you, obviously, with that. After the sale of the business, what we would do is say, okay, let's envision what your future would look like. And many of you on this call would say, the business that I'm in is just a waypoint on the road to the future. I'm in this business. I'm going to get this business rolling. I'm going to sell it. And then I'm going to look for the next business I'm going to set up, and the next one, and the next one, and the next one. And so the planning analysis that we would do would be to say, okay, first, let's make sure that after all taxes, there's enough capital there to support your lifestyle. Adam and I would call that core capital. We want to make sure that you've got a diversified portfolio of an adequate amount to make sure you can spend whatever you want to spend for the rest of your life with a very high level of confidence. Even if the markets don't return, stocks and bonds don't return what we want them to return, if inflation runs amok and starting to show little signs of doing that, although we think that pressure will abate here soon. And even if you live well beyond your actuarial life expectancy, you've got a core portfolio that will support you for life. Anything in addition to that core amount, I would call discretionary or surplus capital. And we would set that up with, for example, an entrepreneurial reserve. So if you wanted to start another business, you would have a few $1,000,000 of capital set aside to do that. And other things that are not covered by basic spending, including estate planning initiatives that you might like to do for family members. The key issue is this. First, get your house in order by doing the basic estate planning steps that Steve described. Second, recognize that the tax laws can change a lot. Steve just showed us that with one little example of the estate tax exclusion and the tax rates that have applied over the years. But the law can change a lot anytime, and especially now with all of the changes that are being considered, both on the income tax and on the estate tax side. If you feel that you're in a position where you might be selling your business at some time in the near future, and you want to consider the possibility of moving some of that interest in your business at its current value, not at its future sale price, but its current value, which is likely to be much lower, now's the time to look into the possibility of shifting some of that future growth into a trust for the benefit of children, grandchildren, others. And by the way, one of the beneficiaries of that trust could be your spouse. A lot of people think that if they're going to avoid estate taxes, they have to transfer assets to their kids and grandkids. Not the case. You can create a trust. The primary beneficiary of that trust could be anyone, including your spouse. You could shift the assets into that trust, or just the future growth of the assets into that trust, and your spouse can be a beneficiary of the trust. Everything in estate planning has an acronym. So does this. It's called a SLAT, Spousal Lifetime Access Trust, a SLAT. And it's a very, very common strategy that entrepreneurs use, because you want to get the estate planning benefit, but you want to keep a thread potentially on that money. And you can do so because in a SLAT, the trustee can make a distribution to your spouse that brings money back onto the marital balance sheet, and you would have access to that at some time in the future. Now, without certain risks, divorce would be a problem. The death of the beneficiary spouse would be a problem. Those risks can be discussed and mitigated. Steve's one of the estate planning experts, one of the best estate planning attorneys in Nashville, can sit down and talk about some of those nuances with you. Adam and I are happy to do that as well. I can't give legal advice. I work for a financial firm. Steve can, and he can give you targeted legal advice for your personal situation. So with that, I think I'd pitch it back over to Adam. Those are the keynotes that I wanted to say. And we know we want to take your questions and look forward to getting those now. We're ready to roll when you are. So Adam, take it away.
Thanks, Tom. Any questions from the group on anything that was discussed or anything in general?
This is Tom Turner. Can you hear me?
Yes, Tom, go ahead.
Sure. I apologize. I was on another call. I was a few minutes late, so you may have covered this. I heard you cover, or Steve, revocable trust. Was there any discussion around grantor irrevocable trust?
No, there wasn't. I would say that we didn't have sufficient time to address that, but we can maybe discuss that. Do we want to discuss it as part of the breakout groups, or is that something that we'd like to discuss now?
Let's go now, Steve. That's a big topic. Let's do it.
Okay. So an irrevocable grantor trust is typically used in conjunction with freezing the assets in your estate. And a simple example is, I own a business interest. I set up a trust for the benefit of my children, and I would sell probably a non-voting interest in my company to that trust. Since it's a grantor trust, from an income tax standpoint, that transaction is ignored. It doesn't result in any income on the sale. But what I take back on that sale is a promissory note with a value equal to the value of the business at that time. All future appreciation of that business interest ends up passing on to whoever my designated beneficiaries are, most likely children and future generations. Meanwhile, I hold a promissory note. If there's a liquidation transaction, most likely I will get paid back on the note, and the appreciation and value passes on to the next generation, and I haven't used any of my estate or gift tax exemption. That's, Tom, anything you want to add to that?
Very well stated. I think I'm just going to summarize. It can be funded with a gift or sale. So you've got a huge exclusion right now. You could just make a gift to such a trust, or as Steve suggested, sell assets to the trust for a promissory note. And the interest rate on that note would be, if it were a 9-year note, 1%, right on the number. If it were a 20-year note, 2% per year. And that's all the trust would have to pay you. It's a grantor trust, which means you're responsible for the income taxes, not the trust and its beneficiaries. Your spouse could be a beneficiary of that trust. You could make this a SLAT. So typically a SLAT is an irrevocable grantor trust. No estate tax would be paid on the assets in the trust at your death or your spouse's death, and potentially for many generations, nor on the future growth of those assets. What might be includable in your estate if you fund this with a sale is the promissory note that you made. But the amount that's includable in your estate is the amount on that note plus any unpaid interest, not the value of your business that you sold, just the amount of the note. So when Steve says it's a freeze, it means you can establish the estate tax value today and let the future growth escape estate tax. An incredibly powerful estate planning strategy. Whether it's funded by gift or sale, Steve, I just think it's a dynamite idea for anybody who's thinking about doing the transaction with the business.
And I agree. Great summary, Tom.
Thanks, guys. What else?
I've got a quick question.
Sure, Brandon.
We had one of our other SAPs present at my forum, and they're awesome as well, and talked a lot about a trust vehicle they referred to as a TIST. Are there distinctions between what you've mentioned as a SLAT versus the TIST? And maybe is it easy to summarize when you might use one over the other?
One of the problems with the acronyms is sometimes people use acronyms that are not familiar, and TIST is not familiar to me. I don't know if it is, Steve. I'm going to look it up now.
Yeah, you're probably, yeah, it's a Tennessee issue, Tom.
Oh yeah, this is the community property idea, right?
No, this is the it's a self-settled asset protection trust.
Gotcha. Okay, go ahead.
It's called a Tennessee Investment Services Trust, and there you go. There's the acronym that confuses anyone from outside of the state. But basically, Brandon, that would be you setting up a trust of which you can be the beneficiary. It would be a grantor trust. It would be irrevocable. You could not be the trustee. You would have to appoint a third party as the trustee, but you could retain the right to income. You could retain the right to encroachments for your health, your maintenance, your support. You could even retain the right to payments up to 5% each year, and you could retain what's called a limited power of appointment, which means you could designate the beneficiaries of the trust after your lifetime through a subsequent will, as long as it's not your creditors. And that trust is treated as a grantor trust for income tax purposes. Typically, it's not going to be outside of your estate. The purpose of it is after 3 years pass, those assets that are part of that trust are no longer subject to your personal creditors under Tennessee law. There's just a handful of states that have self-settled trusts that are protected from your creditors, and Tennessee happens to be one of those.
And just to clarify one point, Steve, it's outside of your estate for probate purposes, but it's not outside of your estate for estate tax purposes, right?
That's
okay.
Correct.
Great. Thanks for that question, Brandon. What else? Anything else?
Taylor Reagan here.
I have a question.
Oh, good.
Just a question: if you sell one company to the benefit of another company, so say, does that just buy you time, or do you get any advantages by having another company own the sale assets and delaying some of the potential taxes?
I think, Steve, this might just be a question about a merger, right?
Yeah, it's either a question about a merger or rolling over equity into a new company. But you may want to give us a little more explanation.
No, if I sold one company that I own with a partner and and then had the sale go to a company that I own solely, what is that taxable in the interim, or how does that work? That's my question.
Assuming you're getting, assuming something other than a tax-free merger or some type of rollover of equity into the new company, and it's not an installment sale, yes, you're going to be taxable.
Okay.
Yeah, I think if you get cash, you'll be taxable in almost every case. And if you were to get a promissory note from the partner, sometimes what your business partner will do is pay you some cash, and a portion of it would be in a note that requires future payments. That note may qualify for installment treatment, which means the tax may be deferred until you receive payments from the partner. It depends on a lot of things, including certain related party rules in the Internal Revenue Code. But generally, cash is going to be taxable. Note might be deferred. If you take any equity interest in the new entity, Steve, I think that potentially could be tax-free because of the way the merger rules work. Is that true?
That is true. And we're seeing a lot of those transactions now where people are rolling some of their equity into the acquiring entity and staying on with the entity.
Right. Taylor, did you have a question?
I did. So with the SLAT trust, if is there a certain time when if the value is under the 23 million right now, but it's going to drastically exceed that, at what time should you go ahead and do that? I'm assuming at the soonest possible to lock it in at the lowest value. And of course, you'd want the value of your company to be valued maybe lower than what for tax purposes. So is there a threshold of when's too early versus when's too late to do that?
Right on target, and probably one of the most asked questions in estate planning. Let's start with this. If the closing on Friday is on Friday, Thursday's too late. That's not going to work. You can't transfer interest in the business the day before the closing. My preference, certainly when I was practicing law, was if I could get you to do the estate planning in 2021 for a sale of the business in 2022, that was ideal. I'd like to be able to do the gift or sale transaction that Steve described within the family in one taxable year and have the sale to a third party happen in another taxable year. That just gave me great comfort that no one was going to complain about the timing of that. If you can't do that, if that's not possible, and this is a year really where a lot of transactions are happening this year, then my rule of thumb is I'd like to see 90 days at least between the estate planning transaction and the sale of the business, but that is not carved in stone. We had one case here this year that was 31 days in advance of the transaction. We'll see if the IRS loves or hates that. But everybody's got a little different view on that. So Steve, I'd like to see what you think about that and how you feel about it. Well, one other thing before I go to it's true that the farther ahead of the business sale you get, the likelihood of a greater discount for the value of your business is higher. So as far ahead of the sale as you can get, you should, but even at any time there's any doubt about the closing of the sale, you should be able to get some valuation discount. It might not be big, but if there's any possibility that the transaction will not close, there should be some availability of a discount based on some discussions that I've had with professional appraisers. Steve, what do you think about all that?
I think the point you raised, Tom, about the year before, I think that's a great practice tip. I mean, I don't know that you would call it law, but it's a great practice tip, and it puts the transactions in two different return years. So that's my preference. I have not always been able to do that just because of the facts as they present themselves. Next thing I would say is, it's best if you can't do that, that you do the estate planning transaction before you have a letter of intent. Even though letter of intents are generally not binding, I would rather have the estate planning transaction prior to having a letter of intent. Once you get a binding contract, I think it's too late in my estimation. And I don't think you're going to, assuming there are no significant contingencies, you've probably limited yourself on discounts too. But we're always concerned over the step transaction doctrine and the IRS coming in and saying, hey, this was no gift before the transaction. So I think Tom and I are in full agreement on that.
I agree.
Tom Turner again. And just in the benefit of experience sharing, having gone through this, two things. One, I think, Tom, you mentioned this. So by selling effectively, I was a partner in a business, and by effectively selling 49.5% of a business to a trust, when we were getting the valuation of our business, because it was a minority shareholder portion of the business, because the trust owned a percent, roughly 99%, and then my business partner and I were left owning 1%, we were able to get a much lower valuation on the business. And it was within a year of the sale of the business. That was done inside of the grantor or irrevocable trust, which helps significantly in terms of our valuation and ultimately tax planning. Secondly, was being able to set up the grantor irrevocable trust, having reached out to a parent. By doing that, having the parent set up the grantor irrevocable trust, then I was able to become the trustee and beneficiary of the trust. So I sold half of the business into the trust. My business partner set up a separate trust. We had parents set up the trust, and then we owned each 0.5%. We got a lower valuation by the parent setting up the trust, and we became the beneficiaries and the trustees for our individual trust, just as a consideration, because it's worked well for us. If you have any feedback, I'd love to hear, but that's what's worked well. It worked well for us.
Yeah, thanks for sharing that experience. That's always the best to hear as some testimony. The type of trust that you describe is called a BDIT, like the Michael Jackson song, a beneficiary defective inheritors trust. And mom and dad set it up and nominally fund the trust, and then you sell your business interest to the trust. some controversy around that strategy. The IRS has sort of made it a focal point of audits in the recent past for various reasons. But you can look at, what are the key elements there? The first is the trust a grantor trust? Tom, when you sell the business interest to the trust, will you be treated as the owner of the trust so there's no capital gain tax recognized? Second, if the trust only has, $5,000 in it, how do you justify it purchasing perhaps up to millions of dollars worth of business interest? How do you establish the creditworthiness of the trust? And the third difficult piece is, did you get the valuation of the business exactly right? If you can check all three of those boxes, then that beat it strategy is something that can work. I've seen plenty of people do it. There's a bit of controversy around it. I again turn to Steve to see if you have any comments on the strategy itself or anything else that Tom said.
They would all be consistent with your comments, Tom, and I think the valuation issue is just critical.
Yeah. Well, thanks, Tom, and thanks, Steve. If anything's clear from this conversation, it's that this is a complex world that is continuing to change. And so, firms like ours and firms like Steve's are here to simplify it for you, to help you pre-experience it before you make decisions, and help make sure you have the right pieces in place so that nothing goes unmissed. So hopefully that was helpful to everybody. Please reach out if you want any follow-up, and I'll turn it back to Brandon.
Yeah, and we're not quite done yet, so everybody don't turn the Zoom off. We are going to break out for a few minutes, and we've got a couple of prompt questions that will be in the chat. And before we go to breakout, I just also wanted to make a quick note from a personal experience share, which is that this stuff might seem far off, or it might seem heavy. I am a pretty young guy, and I had a business partner that was a pretty young guy, and we didn't do a good job of this, and my business partner died, and it was an absolute nightmare. So I'll just say, regardless of your situation, it's never too early to really be thinking about this stuff and planning for it. So yeah, very, very relevant. Here are our breakout questions, and reminder, every small group is going to need a moderator. Number one, what was the most surprising takeaway from this morning in terms of being prepared? And second, can you share a next step that came to you as a result of what was shared? So we'll bounce out to breakouts for a quick chat, and then we'll come back here